Right, but we've stipulated to it. Miss Gothair,
Mhm.
the witnesses, all they can do is testify to your timeline. We've already stipulated to it in the documents, haven't we?
Yes, I just want them to be available to answer any questions about the reason for the delay.
Okay.
So I'm assuming that you will reach out to Mr. or Mrs. Macy
Yes, Your Honor.
because they're not back in the waiting room before we get started. So we're not just like paused and waiting in the middle of our hearing for them.
Yes, Your Honor. May I take a moment to call him?
Mm-hmm.
Just further delays. I made you smile.
I thought I was just gonna have to deal with Abby today, but man, okay.
All right, I can be quiet. I've got different news. My oldest daughter got into Harvard Law and Stanford Law.
So how's she gonna make that decision?
She's going to talk to you and Carmen and.
Well, I didn't go to either one of those schools, so I don't know what I can tell her.
But I named the two people who I trust to give good advice. I think she's going to want to go back to Cambridge. You know,
I think she should go to California, to be honest.
That's why Carmen would say Harvard because that's where she went, and you would say California, and I would
say California because that being over there, just going to law school there, learning their laws, because they're such a different alien from the rest of the country, like in the legal world.
Yeah.
And to have the opportunity to go ahead and take the bar there and practice there, which they're oversaturated with lawyers, that is a consideration to remember. But just the opportunities of network and just having a different experience. I mean, having both Stanford and Harvard on your resume is like really awesome instead of just all Harvard.
Yeah.
You know what I mean? Because Harvard's not number one.
Listen,
Yale is number one.
I said, yeah, I do. I said UT because they offered money, and it was promptly, it was in the mix. Georgetown and UT were in the mix until Harvard and Stanford accepted her. And, you know, we'll see. I'm going to be doing this till I'm 90.
Well, you're better than me because I already told my kid starting 10 years ago when the money was going to cut off at a certain time. So he has about at least 10 years notice of that.
Yeah, I was going to say, it sounds good until you get there.
Till you get there. Yeah, that's what everyone's telling me.
And then they say, Mom, Dad, don't you want me to be whatever?
I had to borrow my money, so hey, he can borrow his.
Right. How's he doing, by the way? Have they gone back or they're still online?
No, they're still online. Yeah. And it's hard. It's rough, man.
Ashley's online. She went back to Philly. You know, she's going to Penn, and she's the smart one in the family. She wants to be a doctor, and she's doing physics and second semester chemistry online. And I said, how do you do the labs? And she said, it's really hard. And so, you know, said, if you get lonely, come work virtually from home. She did that for most of.
Your Honor, he should be on in a couple minutes.
Oh, okay. All right. Well, look, not to interrupt, but we're going to get started. We're back on the record.
Okay.
We have successfully switched on to my laptop that works. And in compliance with the public courts laws, we are live streaming on YouTube. This is the defense's motion. So Ms. Parmalee or Mr. Eisenberg, please state briefly the grounds of your motion.
Judge, our motion to dismiss comes to the court due to a 15-month delay between the occurrence of the offense and the arrest of our client, Mr. Nisi. a 15-month delay until the first setting, which was December 15th, 2020. And we believe that the factors laid out in Barker versus Wingo weigh in favor of the defense, and the remedy being a dismissal.
Okay, does the state have any opening statements to make at this time?
No, Your Honor.
Okay, why don't we at this time, I'm going to admit what has been previously stipulated to States Exhibits 1, 2, and 3. And what the court wants from either side is a rundown of the dates that are relevant in this case, and that both of you stipulate to said dates. So who wants to give the rundown of the dates?
Sorry.
The arrest date is September 29th, 2019. And the first setting of this case is December 15th, 2020.
Is there a file date?
Yes, Your Honor, and it might assist you if I may publish States Exhibit 1, which does have some of the dates on it.
Judge,
When
the
I
file
was-
date's 10/28/2020.
Well, when I was looking at that exhibit, it's a little confusing the way that it's labeled. So you can maybe go through that with the court so I can try to understand it.
Yes, Your Honor.
Judge, while she's doing, I just want to make sure that I gave you the dates. December 29th, 2019, file date 10/28/20, 10/28?
I'm talking about the arrest date is September.
Yeah, I'm sorry. The arrest date, September 29th, 2019. The filing date of the offense was 10/28/2020. The first setting was December 15th, 2020. So a year, 13 months from the arrest to the file date and 15 months from the arrest to the first setting. So we believe the presumption gets us to whatever the defense, whatever the state is trying to explain for the delay.
Okay. So there was, just for clarification, there was 13 months between the date of arrest and the date of the case being filed, and then an additional 2 months from the date of filing to the first setting.
Yes, ma'am.
Yes, Your
Okay.
Honor.
Okay. Let's start with, I think the length of delay being 15 months. When was the date of the speedy trial demand?
Filed that on, Judge, we filed that on December 11th, 2020, after we received notice, I believe, of the first court date being on the 15th.
So I think that the date is calculated from the date of accusation or arrest up until the speedy trial demand. So now you're looking at, yeah, it's still about 15 months total.
Yes, Your Honor.
Okay. So I think a 15-month delay sufficiently triggers the Barker-Wingo analysis. So we can move to the second prong, which is the reason for the delay. And just for clarification, that the 15-month is, meets the first Barker-Wingo factor in that it's presumptively prejudice to the defendant. Okay. So the state, let's hear about the reason for the delay.
Yes, Your Honor. I would break down the delay into 3 different time periods in this case. Again, the arrest was made in September 29th of 2019. The delay between that date and April 28th of 2020 was due to pending lab results. The state would argue that that delay is neutral because it is not due to any negligence from the state or any of our agencies. There's no evidence that that time was longer than necessary and normal for the lab results to come in. And it is showing of our due diligence to make sure that the lab results are entered before we file a case to make sure that the defendant should be accused. The second delay would be between April 28th of 2020 and when the labs were finally received by the Mesquite Police Department, which was in October 13th of 2020. The witnesses can testify to the reason between that delay, but in summary, it comes down to a miscommunication in terms of email as to whether those labs were received on time. The state would argue that that delay is due to the state, but only slightly due to the very small amount of negligence. And then the last delay is between when the case was filed, which was just a few days after the labs were received by the agency and submitted to us, which was October 28th of 2020. And when the first setting was, which was December 15th of 2020. That first setting is not in the power of the state, that is set by the court, and therefore the state would argue that that delay is neutral.
Hold on one second. Okay, does the defense want to respond to the state's proffer of the reasons for the delay?
Sure. I would just say this, Judge, that if they're trying to say that they didn't file the case because the labs were being done, that's not an explanation that prevents them from filing the case, because on a misdemeanor case, all they have to do is have probable cause, reasonable suspicion, or community caretaking in order to arrest somebody without a warrant. They do it all the time, and they file all kinds of cases, both misdemeanors and felonies, without lab results. And there's nothing that would prevent them from being able to prove a prima facie case with or without labs. So, I mean, the explanation that it took them a while to get lab work done just doesn't hold any water. The time ticks when they arrest somebody based on the fact that they do have probable cause or reasonable suspicion or community caretaking. And they can prove and try DWI cases all day long, and have for as long as I've been practicing law, 41 years, with just the testimony, opinion of an officer. And so that's not a neutral or sufficient explanation as to why the case wasn't filed for 13 months.
I mean, having heard the defense's argument state, is there like anything unique about this case that would necessitate waiting for lab results for some specific reason strategically that would make sense to the court that may lend this to not be a reason that's at the fault of the state delaying the case?
Your Honor, it could be because this case is a DWI above a .015. Why it was not filed as a DWI originally, I cannot tell you. What I can tell you is that this case was not submitted to us as in the district attorney's office, until after the labs were received by the agency. Well, obviously any negligence caused by the agency is also attributed to the state. It was their decision to wait for those lab results.
What agency is this?
Mesquite.
Is this like a standard operating procedure for them, or?
I do not know, Your Honor.
I mean, you have witnesses in the waiting room, correct?
Yes.
Do you want to question them, or because right now it looks like you don't know why they took so long to, first of all, get lab results, second of all, to turn them over, third of all, to file the case, not necessarily in that order. So do you want to question them? Because I mean, without that information, I don't think that I'm having sufficient reason for delay that's not attributable to the state in a negative way as it pertains to this motion.
Yes, Your Honor. I may proceed with the questioning of the witnesses.
So let me see if I can get back to the waiting room. All right.
Good.
What witness do you want to call?
The state calls Andrew Macy.
Good afternoon, Mr. Macy. Can you hear me? I think you just muted yourself.
I did. Okay, how about now?
That's good. Can you hear me okay?
I can, yes.
All right. I'm Judge Julia Hayes. Welcome to the virtual courtroom for Dallas County Criminal Court number 2. Assistant District Attorney Kotari is calling you as a witness. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And what is your name?
Andrew Macy, M-A-C-E-Y.
And did you agree, sir, to appear and give testimony over Zoom video conference?
I did.
Okay, go ahead, state.
Good afternoon, Mr. Macy. What do you do for a living?
So I'm the blood alcohol section supervisor at the Texas Department of Public Safety Garland Crime Laboratory.
And how long have you done that?
I've been a section supervisor since 2014 and been with the DPS Garland Laboratory since 1998.
And what are your responsibilities in your position?
As a supervisor, I try to get everything that the analysts need to continue their work, to do their work. I hand out cases. I bring DPS blood kits from the first floor up to the third floor. Since I've been with the Garland Laboratory since '98, I was a forensic scientist before, and so I'm still a forensic scientist to analyze blood cases. So I still do work in that area, answer phone calls, review cases, and other supervisory skills such as ordering supplies and taking care of their needs.
And can you briefly explain to the court how the lab reports for each case is generated and sent to the agencies?
So the lab reports are generated by our LIMS, our Laboratory Information Management System. An analyst would go in, complete a case, fill out the report, they would check it, and then after they're done, they would give it to another analyst that is qualified in that discipline. That second analyst would review the data that was generated from that case. Then they would sign off on it as technically reviewed. And then they would go ahead and also review all the administrative notes on it to make sure spellings are correct, offense dates are correct, and all that is in the right area, in the right place. And then they would sign it off as administratively reviewed. Once that has been administratively reviewed onto the LIMS system, the computer system, it automatically sends out emails to whoever are on the bottom of the report to get that report.
Your Honor, may I publish State's Exhibit 2, which has been redacted?
Sure. I think I enabled sharing.
Yes, Your Honor, sorry, I'm looking for the lab report. Sorry, Your Honor, I cannot share my screen. You are sharing your screen currently.
Am I?
Yes.
Try that now.
Not yet.
What is it? What is it we're trying to share? Isn't the lab report there, Judge?
I have the lab report. I'm not sure if Mr. Macy has it in front of him. I think you guys have it in front of you. So
Okay. What is it they're trying to, I'm just sort of confused at what we're doing with this.
I was just having the witness explain the lab report and what happened in terms of sending it to the agency.
Okay, well, explain what the lab report is irrelevant to the motion for a speedy trial or for an explanation for the delay. So why don't you, I'm sorry.
is that an objection?
It's an objection, Judge.
Sustained. So counsel, let's get to what Mr. Macy's role is, if any, in delaying the movement of information in this case and the filing of this case.
Your Honor, Mr. Macy is capable of testifying to reasons why the lab results did not make it to the agency on time.
So that's what I want him to do. So let's get to it.
Yes, Your Honor. Mr. Macy, can you account for any reason why the agency did not receive the lab results in April, as the lab report indicates?
I cannot. I do know that we send them out by email, and this case happened to be technically reviewed and administratively reviewed at our Wessico laboratory. So once they reviewed it, both technical and administrative, then it was sent from their location. So I do not know what caused the email not getting to the Mesquite Police Department.
Has the lab ever had any issues with errors of the emails not being sent down when the labs indicated?
We have. Every now and then we'll get a request back saying, I didn't receive the email. Can you resend it? It doesn't happen often. A lot of times when it does happen, we do get a notification that it was not sent. And so it does happen every now and then.
And is it possible that the agency reached out and received the labs at a later date?
Yes, it is possible.
And can you just briefly explain to the court why the labs had to be transferred to a sister lab in this case?
In 2020 and actually 2019 and 2020, the blood alcohol section had a very large backlog. And so we also only had 2 analysts at the time through 2019. And so to help us out, we would send them to another DPS laboratory to technically review them, to help those analysts continue to produce reports, to get cases out and have somebody else and administratively review them.
Pass the witness.
We don't have any questions, Judge.
Okay, thank you, Mr. Macy. You may step down virtually. Thank you for coming. And you can leave the meeting if you'd like, and you can go back in the waiting room just in case we need you, if you don't mind.
Okay.
Happy New Year.
Thanks. Happy New Year.
Take care.
All right, State, do you have any other witnesses?
Yes, Your Honor, the state calls Patrick Pellegrini.
The rest you know.
It's the evidence coordinator.
Mr. Pellegrini, can you hear me? Good afternoon. You're muted.
Can you hear me?
I can hear you now.
Okay.
Thank you.
You're welcome.
Letty, we're still on the record. Is that right?
Yes.
Okay. Can you raise your right hand, sir? Are you Patrick Pellegrini?
Yes, ma'am.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And did you agree to appear and testify over Zoom video conference with us today?
Yes, I did.
Okay, you can put your hand down.
Thank you.
State, you may proceed.
Mr. Pellegrini, what do you do for a living?
I am the property and evidence supervisor at the Mesquite Police Department.
And how long have you done that?
Almost about 20 years now.
What are your duties in that role?
My duties are to supervise two other individuals. One of them's a tech who works all the property, and the other one does all of our scanning and answers phone calls, does the duty work of taking care of the officers and the public.
And in your job, do you communicate a lot with the DPS labs?
Yes, I do.
States Exhibit 3 is an email between you and one of your employees. Did you review that email prior to this hearing?
Yes, I did.
Were you the recipient of that email?
Yes.
Who sent that email?
Ellen Honorado did, our CID secretary.
So what is her role?
Her role is to work all of the cases that come in, whether it be DWIs or narcotics. And she basically uploads everything to the server, all the cases up to the server in Dallas County.
And does her role involve whether or not a case is submitted to the office, or does she just upload the labs?
I'm sorry, could you repeat that one?
Does her role involve whether or not a case is submitted?
No, I submit all the evidence to the labs.
Okay. And why did she send you an email on that day?
She sent me an email on the 8th of October about 11:32 a.m. about, there was actually about 40 cases that we had not received lab reports back on.
And was one of those cases a case against the defendant, John Z?
Yes.
And do you have any reason to know why that lab did not come to your agency when the lab report indicates in April?
No, I can't answer that. Like I said, on that 8th, that when I got that email from Ellen, I then turned around and emailed DPS Crime Lab to ask them if they had worked the evidence yet, and also if there had worked it, if there was a lab report that had been submitted, and if it hadn't been submitted, if they could please send it to me through the lab reports group email that we have. That's where we get all the emails from. And I did not get a response back from them. All I got was all of those lab reports handed to me the next time I went in on the 13th of October. And then once I received those lab reports, I brought them all back to the station, had my secretary scan them all in and send them up to Ellen so she could upload them to the portal.
And can you testify as to why this case was not submitted before the labs were received?
Why it was not submitted?
Yes.
We never received it.
Is it the agency's policy to not file a case or submit a case to the DA's office until the lab is received?
Usually Ellen does not submit labs to the Dallas County DA's office until we've received them.
Pass the witness.
I don't think that answer was responsive to the last question. Ms. Hernandez, can you read back what Mr. Pellegrini just said?
Answer, usually Ellen does not submit labs to the Dallas County DA's office until we receive them.
And I believe the question in essence was, is it the agency's policy to not submit the case for filing until receiving labs? It wasn't that the essence of your question, Ms. Katari?
Yes, Your Honor.
So that answer was non-responsive. If you could try to answer the question, sir, that would be most helpful.
After hearing the question again, I don't know that I could answer that. I'd have to have Ellen answer that question because that's her part of the job. That's not my part of the job. My part of the job is just to get the lab reports for her, the ones that she's missing, and get them to her so she can do what she does in her job.
Okay. So your answer is you do not know.
Yeah, I mean, I really don't know.
Okay. Are there any other questions of this witness?
No, Your Honor.
You passed the witness?
Yes.
None from the defense, Judge.
Okay, Mr. Pellegrini, you may go back into the waiting room and just hang out for a bit just in case we need you, okay?
Okay,
You may step
thank you.
down. Thank you.
Uh-huh.
Okay, does the state have any more witnesses?
No, Your Honor.
Moving to the next prong of who's at fault for the delay. Mr. Eisenberg, since this is your motion, you want to argue and let us know who you're alleging is at fault for the delay?
Judge, I'm happy to argue. I would just say that the delay is not caused by the defendant, and it's not the defendant's responsibility to call the state up and say, where's the case, or where's the labs, or anything like that. So the fault still lies with the state. And even in the best of circumstances, if they have some policy, I'm just kind of anticipating what they might argue. Delay of labs, delay of filing cases, it never rests with the defense. And if they have a policy that harms them, they should change the policy. But there's nothing that precludes, the court knows this, but there's nothing that precludes the state from filing cases. They do it all the time, and then find out labs. So I guess
excuse me, Mr. Eisenberg.
Yes.
So as to keep this as organized as I can, I'm going prong by prong.
Yes.
The prong that we're on right now is who's at fault for the delay. So I would like for the defense to articulate, who are you arguing is at fault for the delay? Are you arguing it's the state?
Yes.
The law enforcement, the lab techs? Who are you arguing? Just so I can get through my legal analysis. Don't go into your summary argument at the end.
Sorry.
We're not there yet.
I apologize, sir.
That's okay. Just tell me who you are contending is at fault for the delay.
The district attorney's office is at fault collectively because of they're responsible for the case law defines them as everything, including the clerks of the court and the police agency. So it's the state.
Okay, and can you tell me specifically who you are saying is part of the state?
I'm saying to the court that part of the state is the law enforcement agency that made the arrest, the lab that didn't do the analysis or get the analysis to the police agency, and then the delay from when the case was filed with the DA's office to the first setting. So that would be the county clerks or the county courts coordinator, whoever's responsible for that part of the delay.
Okay. What does the state have to respond on the issue of the who's at fault for the delay prong?
Your Honor, it seems that the delay in this case was caused by miscommunication between the DPS labs and the agency. I would agree that that delay should be attributed to the state, but if so, very slightly, because it was not caused by any intentional delay, and the negligence is very slight in this case. Our witnesses did not communicate that there was any change in procedure from the norm or that their normal procedures is negligent in any way in those labs being sent out. In addition, the agency themselves did go through their cases and ask for the labs that they found were missing.
Okay, I think the next prong is the defendant's assertion of his speedy trial right. And I think taking judicial notice of the court's file, that speedy trial demand would have been filed on, can you guys remind me the date, defense, when you filed that demand?
December 11th, 2020, Your Honor, at approximately 12:57 p.m.
And then the motion to dismiss, was that filed on the same day or a different day? Remind the court, please.
Same day.
Yes.
Okay, so the court takes judicial notice of the defendant's assertion of his speedy trial right via a speedy trial demand and the motion to dismiss for violation of the speedy trial right, both of which were filed on December 11th, 2020. Now we go to the prejudice to the defendant. Did you want to call your client or do you want to?
Judge, we submitted an affidavit of duress, and it was filed also on December 11th, 2020. So we would submit that as defense exhibit number 1.
Do you have that? Have you previously provided that exhibit to my court reporter?
No, I thought we were.
Well,
This is part of the court's file.
I'm sorry, it's part of the court's file, and I'm not sure who has actual possession of it. But we can do it, but it was in the motion,
Right.
and so I don't know where it is virtually. It's on base.
I'm taking a look at that right now. I have it.
Okay, thank you, Judge.
Okay, there's a lot of information in this affidavit, counsel. Have you taken a look at the affidavit, state?
Yes, Your Honor, and the state would request an opportunity to cross-examine the defendant on his affidavit.
What says the defense on that?
Whatever the pleasure of the court is, I think the affidavit in and of itself is sufficient to trigger the 4-prong harm analysis. I think we've met those prongs, but certainly, if the court wants to hear from the defendant, we can call him. I don't think it's necessary, but whatever the court wants to do.
I'm looking at the affidavit. Now, mind you, counsel, and you understand how it feels. As the judge, I have no knowledge of the facts of this case.
Sure.
One of the things that your client is saying in this affidavit is that there are medical records that could have been obtained, but are now unavailable.
Correct.
Having been an attorney and being a person, a steward of the law, if you will, that's not usually the case. You can usually get medical records within 2 years ago, 3 years ago. So I'm curious about what that means.
Okay.
I'm curious about a conclusory statement that I suffered great anxiety. That's not really telling me anything, because the case law on this matter discusses kind of implicit anxiety that most people go through, but we want to know, I mean, and there's some presumptive anxiety, but if there's some proof of that or some expansion on that your client can offer, it would certainly help the court in the prejudice, the prejudice to the defendant analysis.
Okay.
Witnesses that have not been located or cannot be located. To just say that you can't locate someone is not really sufficient without some background information as to the efforts to locate those witnesses. Perhaps the state has some witnesses that they may plan to call the same witnesses. It's just like a lot of conclusory statements that, quite frankly, are not enough for this court to just conclude prejudice to the defendant.
Okay.
Okay. So if you want to call your client, I would suggest you call him because it's your witness.
Okay. Got it.
Rather than the state calling them as potentially a hostile witness.
Okay. Okay.
And this is for the purpose of the discussion of the speedy trial right only, not facts of the case and whatnot. Okay, you guys? Thanks. Go ahead. Call your client.
Yes.
Sir, can you hear me from where you're sitting?
I switch seats.
Just pull up another chair.
What if he just sit in this one chair? Mr. Nisi, just come in. Just sit right here. Let me off camera first.
Can we get organized for just a second, Judge?
Okay.
We're gonna mute.
Okay.
Okay, Judge, we're gonna let Ms. Parmelli, she's had the interaction with the client about those things. And so she's going to call him and direct him, and I'm gonna still be here somewhere.
Okay.
Sorry about that.
Mr. Nisi, can you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, I'm going to need you to speak up louder so my court reporter will be able to hear you through the duration of your testimony, okay? Are you John Nisi?
Yes, I am.
And do you agree that we're having your hearing over Zoom video conference?
Yes,
And you agree to testify over this video conference in your hearing, is that right?
yes,
And you understand that you're being called to testify on matters related to the speedy trial motion only?
yes, Your Honor.
Okay. Ms. Parmalee, you may proceed.
Sure. So, Mr. Nisi, we've talked and you've signed this affidavit. What we're needing is to articulate, the specific anxieties you've suffered and articulate to the court. Just tell the court what you've been through this past 16 months now. Due to the arrest that happened on September 29th.
Sleepless nights, worries, can't go out, I can't do anything.
Can you speak up?
Sleepless nights, worries, stress, I can't get a job. Anywhere I go, they pull it up and it's there. When I tried to explain to them, they said, well, come back when it's done. And it's been so hard for me and put undue burden on my wife because she's been carrying the load in trying to help. And sometimes I feel she might leave me because she's doing everything, and I'm diabetic. I've been diabetic for 18 years. Most of the medications that I get, to pay for them is very hard, and sometimes my friends help me. So all this creates so much problem for me. I've lost over 30 pounds since this thing happens, and it's been traumatic to me and my family, my kids also, because they look up to me, and I try to do the best I can, but the issues are just so much, because every day I wait hold my phone. Even when I couldn't pay for my phone bills, I had to find a way to get it so that in case I get any call. So it's been very stressful for me.
And Ms. Nisi, in 2019, were you being treated for diabetes?
Yes.
Okay. Are you still going to the doctor, or are you able to see your doctor regularly?
Yes.
Okay.
I've been diabetic for 18 years now.
Okay. And then you mentioned friends. Without going into details of the case there, when you say friends, would those have been people that you were hanging out with the night of the 29th?
No. On that 29th, we had people that came from overseas that were our schoolmates and class friends that came, and they had a meeting. They had a convention here.
Right.
So
but they don't live here.
They don't live here.
And
so
they live in, where do they live?
Some live in England, some live in Nigeria.
Okay, so it would
we
be difficult for them to come back to Texas.
Yes.
Correct. Is there anything that you, as far as like your medical records are concerned, I think we need to parse that apart. Was there anything going on in 2019 that you think would be difficult now, a year and a half later, to obtain as far as medical records?
I know I changed Dr. early then, and the medications have also changed, and because when they test you, all I've been trying to do is to avoid taking insulin, and when they change any new thing that comes, then they'll test me and I'll go and start trying, and the doctor will do that. Because I'm not able to pay most of the time, it's not easy for me to get some of the things that I need to get from papers from them.
Is there anything else that you'd like the court to know or the state to know that we didn't cover about your anxiety or what's going on in your personal life?
We just like this issue has changed my life, and it's been so difficult for me to continue. Sometimes I think negative, but my young daughter holds me up.
I'll pass the witness, Your Honor.
Hi, Mr. Nisi. You mentioned some jobs that you were unable to get due to this case. What are some of these jobs that you applied to?
Like getting a job with an insurance company so that I could help be an agent and open account for them. Open account for people, sell insurance.
Are there any other jobs you applied for?
Yes, trying to be a biller for a home health agency.
And how do you know that this case is the reason why you did not get those job offers?
Because when they run your background and they ask you questions, you're honest with them. And then they look at it and say, no.
And you mentioned anxiety. Did you ever visit a doctor in reference to any anxiety or any symptoms caused by your anxiety?
I talked to my doctor about this and about my what happened to me and about this case. And he advised me and talked to me and said that when the case is over, because my blood sugar has been spiking so much, I can't sleep, and I have so much worries and stress. So I talked to my doctor about it, but he can't transfer me or give me a referral to specialist because I can afford it.
And how long have you been diabetic, sir?
18 years.
And lastly, do you personally, do you have any knowledge of the witnesses in this case that could help or hurt your case?
Can you repeat the question? Zui?
Yes, Mr. Nisi, do you personally have any knowledge of the witnesses that could be called in this trial and whether or not they're available?
Yeah, those my friends, especially the ones that they traveled back after the convention, they came back, because those are the ones that are certain. And
No further questions, Your Honor.
Is there any redirect from the defense?
No, Your Honor, nothing further.
Okay, the witness may step down.
thank you.
Oh, you're welcome. Does the defense want to call any other witnesses?
No, Your Honor.
So both sides rest and close.
Yes, Your Honor.
Yes, Judge.
All right, I'll listen to arguments at this time. I think the defense opens and closes since it's their motion. So defense, you can start.
Okay, I'll start, Judge, and let Ms. Parmalee finish for the defense. And it's simply this: it's 15 months is well past the 9 months that the Supreme Court thought about a sufficient time to bring somebody to trial on a simple misdemeanor charge. They certainly had a long explanation about what was, the difference between a complex felony case where there might be, late developing evidence and all that sort of stuff. And that, they sort of came down, the simpler, the smaller the charge, the less time for the state. I think we're past that hurdle. I didn't hear anything about a neutral explanation or any explanation as to why the case couldn't have been filed, within the week of the arrest of the defendant. So then we go to the harm analysis. And of course, this is the most subjective part. It really gives the total discretion to the court to weigh and balance all the factors. So one of the factors, no matter how slight, if there's any factor at all that registers, then the benefit goes to the defendant, as I understand Wingo, Barker, and Doggett. So the analysis is simply that he is harmed, one, by getting arrested, two, by the trauma of being charged, three, by the trauma of getting a bill from the Eisenberg law firm for legal representation. And then he has suffered, because of the delay, it's harmed his ability to get work. Obviously, his testimony is about as an insurance agent, a healthcare provider agent, and that when background checks are done, DWI shows up and they say, get that resolved before we can hire you. So he can't get the work that he needs to get. In addition, the stress and anxiety where he can't sleep and his blood sugar spikes because of the diabetes, with anxiety and nervousness because this thing has been hanging over him, then it's affected not only his health, where he's lost 30 pounds, but it's also affected his marriage, where the stress is apparently on his wife, and they've contemplated divorce or whatever because of this hanging over him. And then finally, the witnesses that could have memorialized their testimony sooner, you know, have departed for England and for Nigeria. And so at this late date, their memories probably faded a great deal. They probably haven't thought about this the way that Mr. Nice Eyes thought about it. And the ability to get them to either record their statements by affidavit or recall what happened on the night of September 29th is gone because of the delay. And the court knows that memories fade over time, and the longer the time, the longer the fade. And so 15 months is a big time to remember the nuances of an evening where they weren't asked immediately to memorialize or recall what they could recall. So for those reasons, we believe we've met all the prongs and are entitled to a dismissal based on the speedy trial. And we reserve the rest of our argument for Ms. Parmalee.
Okay, State.
Your Honor, I'll start with the first prong, which is the length of delay, which in this case was 15 months. And so the state will concede that delay does trigger the analysis. Moving on to the second prong, the reason for delay. As stated before, the first period of delay from the arrest to when the labs were received, that is a neutral reason. In Stewart v. State, the court held that because there was no evidence that the delay in the lab was the result of inefficient procedures, carelessness, or untimely requests by the state, that prong was held in favor of the state. And then in Bertrand versus State, it was held that even though the state failed to submit the blood for 1.5 years, the court still held it only slightly against the state. In this case, the blood evidence was submitted just a couple days after the arrest. So there is no evidence that there was any negligence in submitting that evidence or getting the lab results done in a timely manner. Testimony by Andrew Macy indicates that there was no negligent acts upon the labs that led to a delay in those labs being sent over to the agency. The delay that the state believes is most important is the delay between April of 2020 and October of 2020. And that delay seems to be caused by some kind of technical issue with emails or miscommunication between the agencies. And the state would contend that that is to be held against the state, but only slightly. There is no evidence that there was any intentional delay in order to cause some kind of advantage to the state. There is only a very small amount of negligence shown by the testimony of these witnesses. The agency themselves went and asked the DPS labs for those lab results once they realized that they had not received it. And for those reasons, the state believes that the first period of delay is neutral, and that second period of delay is should be held only slightly against the state. The third, moving on to the third prong, the assertion of the right. This case was filed in October, and the assertion of the right and the dismissal were filed in December 11th of 2020. While this case was not indicted, Cantu v. State cited the Supreme Court in Dillingham versus United States when they stated that the invocation of the speedy trial provision, while it need not await indictment information or formal charge. In Cantu v. State, the court stated that that an incompetent defendant must show that he tried to get the case into court if he never asked for a speedy trial prior to the dismissal. The court stated that an accused arrested but not formally charged, such as in this case, has a choice. He can wait until he is charged, then file a motion for speedy trial, and if this request is not honored, he can then file a motion to dismiss. In this case, the defense has not produced any evidence indicating that the defendant tried to get this case into court before the indictment. Therefore, the appropriate remedy in this case was simply to make a speedy trial demand and not a dismissal. Moving on to the last prong of prejudice, the defendant did state he had some anxiety. He does not indicate any kind of specific medical issue. He states that a lot of his medical issues on anxiety is related to his diabetes, but he did testify to this court that his diabetes he's had for 18 years. In addition, he states that he had trouble getting jobs. He was only able to state 2 jobs that he applied to. And I do not believe that defense has proven in any way that he knew that those jobs were denied to him because of this case. In addition, this prejudice has to originate from the delay itself and not these cases, not this case in its entirety. All of these prejudice that the defense attested to were problems that he would have even if the case had been filed earlier. Obviously, a arrest for a DWI like this will cause anxiety, will potentially affect his monetary capabilities, and will affect his employment. I believe that the defense has not indicated that it was the delay itself that caused these prejudice to the defendant. Lastly, in Cantu v. State, the court indicated that silence during the entire pre-indictment period works against the defendant because it indicates that the hardship was minimal because of that delay. And for these reasons, the state would ask the court to deny the defense's motion.
Let me ask that reference to case law you just made. Are they referring to silence of the defendant, meaning a non-assertion of a speedy trial demand or motion? What do they mean by the defendant's silence?
Defense silence indicates that they believe that if a defendant wants a dismissal outright at the time of indictment, he has to have shown that he made attempts to get himself in court pre-indictment. In that case, they referred to potential conversations between defense and state in terms of getting the lab moving or the case being filed.
Have you submitted these cases that you're referring to the court?
Yes, Your Honor.
Okay. Defense, final words?
Only judge that, obviously one state does concede to the link triggering the inquiry and being presumptively prejudicial. The case law that state gives for the reason of delay, the Stewart and Bertrand cases are opinions designated as do not publish. So judge, those are not cases that would have any precedence over the court's opinion, the court's decision today. The defendant did assert his right in a timely manner, even if he hadn't asserted it at the time. I believe it was still a reasonable time from notice of the first setting that we requested and demanded the speedy trial. And Judge in Strunk versus United States, the Supreme Court of the United States states that the remedy for a speedy trial violation is a dismissal. And lastly, as far as the prejudice prong is concerned, the delay, I think we showed the court, portrayed to the court that the length of delay and the not knowing how this case is going to play out did directly cause this anxiety, the job loss opportunity, and we would have to wait 9 to 12 months before we could even bring up this subject. So I just think that that's not a relevant argument either. And for those reasons, again, Judge, we ask for dismissal in this case.
All right, I'm going to take this case under advisement. Give me the opportunity to review the, I know the defense submitted several cases and to review the state's cases. And I'm also interested in the issue of how the courts balance the statute of limitations with the speedy trial right.
Yes,
And if you could find it specifically in misdemeanor cases, because obviously, you know, the larger, longer statutes of limitation may not give us scenarios that are applicable to our case. So, because I know that there's case law on how to balance the statute of limitations, the fact that these agencies have 2 years to file their cases with the speedy trial right.
yes, Judge.
Yes,
If
Your
you
Honor.
guys could give me a brief on that, I would love that.
Yes, Your Honor.
Not just cases, but a brief telling me issue, rule, application, conclusion.
Yes, Your Honor.
Yes, Your Honor.
Okay, we're off the record. Thank you all.
Thank you, Judge.
Oh, let's go back on the record.
Okay.
I'm
Timeline.
going to reset this for a ruling that's going to take place on the afternoon of January 28th. So defense, you get with Roxanne and schedule a Zoom for that afternoon. 2 o'clock is usually my time for speedy trial motions. That's when I'll pronounce my ruling.
Yes, Judge. I will do that. Does the defendant need to be present on the 28th?
That's up to you all. I'm just going to go on the record and state my ruling, findings of fact and conclusions of law. So he's not required to be present because we're not going to be asking questions and all of that.
Understood.
Thank you, Judge.
All right. Thank you all. It's good to see you. Have a good rest of the short week.
Yeah,
Thank you, Judge.
please be safe.
You too. Oh, I will. And I have been for 11 months.
Okay. Are you coming to the, I don't know, because I haven't been myself, but once, but are you going to the courthouse at all, or
No,
everything's remote?
everything's remote. I've only been up there maybe twice in the last almost year.
Wow.
And that was just to give one of my clerks a baby shower gift. And another time, I think I went up there to get like some research, some legal research stuff. But that's it. We're not appearing in court.
We miss you. We miss seeing you, but maybe this is the best way. We can just Zoom and visit.
Absolutely.
Okay. Thanks a lot.
Thank
Take
you
care.
all. Have a great afternoon.
Do my best, everybody.
I will. You too.
See you tomorrow, Judge.
All right. Bye-bye.
Bye.